Hello folks, I'm Stanley Santire. As a mediator who often deals with workplace issues, I'm curious about the trends that are impacting the American worker today. Now, based on my experience, both as a mediator, as an arbitrator, and in my trial work, I believe we have really three profound issues that confront the American worker. They are mandatory arbitration is one of them, non-compete agreements, and trade secrets. Now, the mandatory arbitration means that basically what you do as an employee when you sign a document whereby you're agreeing to arbitrate any sort of dispute, you're waiving your right to go to trial. You're not going to get a jury, you're not going to get a courtroom, you're going to get an arbitrator. What has happened is that we have some specific statutes in this area. The most important one is the Federal Arbitration Act, and that dates all the way back to 1925. Much more recently, we have the Texas General Arbitration Act, which is of 1965. The significance of this, though, is that for a long time, for example, with the existence of the Federal Arbitration Act, nobody saw that it actually controlled workplace relationships between employer and employee. In other words, could the employer require the employee to agree to arbitration? But that has been significantly changed, and the courts have said, yes, it can be done. The employer can require the employee, when you go to work, just tell you, if you're going to work here, you need to sign this, or even if you've been working there for several years, and the employer comes to you and basically says, if you want to continue working here, you're going to have to sign one of these things. You really don't have any choice if you want to keep your job. That, of course, raises the issue about what we used to call contracts of adhesion. It used to be, when I was in law school quite a few years ago, the idea was we had this concept of contract of adhesion, and in that concept, if one party to a contract was overwhelmingly powerful and the other party didn't have much choice, there's a possibility that that would not be a valid agreement. But the courts have pretty much thrown that out insofar as these arbitration agreements. We know that the employer has the more powerful position. Say either I don't hire you, or you don't work here any longer if you don't sign this. So the contract of adhesion concept does not really apply. The second trend I was mentioning has to do with non-competes. Now, non-compete is basically a situation where you agree not to compete with someone. It might be your employer. It could be that you're a franchisee in a franchise, and they tell you if you want the franchise in a certain area, you're not going to compete with people in another area. It might be a situation where a tenant in a mall has an agreement with the landlord that nobody within the mall can compete with that particular tenant. But where we find the most non-competes is actually in the workplace, employees. In fact, the numbers that I have seen, the statistics indicate about 18% of all workers in the United States are subject to a non-compete. That's 30 million people. And we believe that that number is significantly growing in addition to the fact that courts have increasingly, in the past few years, enforced these things. Now, the elements of one of these non-competes is that the employee, of course, has to get some sort of consideration. I mean, the employer has to do something for them, and that's a complex issue as to what that consideration can be. The issue of how long a non-compete can last, usually they apply to when you leave the employment. Is it 1 year or 2 years or 3 years that you can't compete with the employer? What's the geography? In other words, what general area, how big an area are you prohibited from competing? And of course, the issue of the range of employment. Just what is it that you're prohibited of doing insofar as one of these non-competes? The best thing the employee can do, if you see one of these things, if it's possible, before you take the job, you ought to talk to a lawyer about it. If you are working for an employer and the employer wants you to enter into one of these things, you need to talk to a lawyer. Same thing goes, of course, with the employer. Any employer that wants to put these things out there and require employees to sign them needs to understand just what the limits are as to what they can require of the employee. The third factor, or the third trend I was referring to, is trade secrets. And this is growing a great deal today. Basically, a trade secret is information that is used in a business and it presents an opportunity to get an advantage over competitors who do not know the information or the trade secret. This is natural in a world today where information and technology are the key to success for so many companies. Now, primary reason for doing this, for companies having these trade secrets agreements, is that, of course, of all the people that will know your trade secret and could share them with other people, it's going to be your employees. So we've seen a great deal of growth of these things insofar as the employer-employee relationship. And in Texas, we've even created a statute. We had the legislature pass what is called the Texas Uniform Trade Secrets Act. And it controls what type of protections you can have as an employer and what obligations you can have as an employee when it comes to trade secrets. We also had the federal government pass what is called or was termed the Defend Trade Secrets Act. Okay, so we have both state law and federal law on this issue. The key to the whole thing is that this can be a profound impact both on the employer and the employee, and both of them need good guidance. And if you're engaged in a mediation over one of these things and you're a lawyer representing someone, you really need to have a substantive understanding of this concept because they're pretty complex. And so I just wanted to share those. There's other trends taking place in the workplace, certainly, but these are some of the more profound things that are happening in our society. My name is Stanley Santire, and I deeply appreciate this opportunity to share this with you.